This is a Disney story, although it's about as un-Disney of a story as you can get. It's about forced, mandatory arbitration agreements, contracts that can prevent you from bringing claims in court and in front of a jury. My name is Shaunak Darup. I'm a partner at Orange Davis Law in San Francisco, and I'm a civil litigator. Today, I'm going to talk to you about a topic that is very near and dear to my heart, because I spent the first half of my career almost exclusively trying to get around these things. Forced arbitration agreements. Arbitration agreements are contracts that basically say any dispute that you have between yourself and the company have to be in binding individual arbitration, which means you can't bring those claims in court, which means you can't bring those claims in front of a jury. So here's the Disney of it all. A man and his wife were at Disney World and they were eating at a restaurant. Allegedly, she told the workers there that she had certain severe food allergies. When they got the food and she ate it, she had a severe allergic reaction and subsequently she died. The man sued Disney for wrongful death. Disney countered by saying, you can't sue us in court. You signed an arbitration agreement that says you have to bring any disputes you have in individual arbitration with the private arbitration provider. But here's the thing. Disney said, you signed that arbitration agreement when you agreed to use Disney Plus, our streaming service. Back up for a second. You know how when you sign up for a new service, whether it's on your phone or a streaming service, there's that big terms and conditions page? Disney was saying, you can't sue us for wrongful death because when you signed your Disney Plus agreement and you clicked I accept, you were agreeing to submit all the claims that you have against us ever, any disputes against the Disney Corporation, in binding individual arbitration. And that includes this wrongful death claim. Now, this is a particularly severe example of a corporation using a binding arbitration agreement to enforce arbitration against an individual. And there was so much backlash that Disney did eventually relent and say, we are going to waive the arbitration provision and allowed the case to move forward in court. But they didn't have to. That's the key. Disney could have just enforced the arbitration agreement and gone into arbitration because these arbitration agreements are incredibly powerful. Now, you'll find these contracts in everything from nursing home admission contracts to cell phone provider contracts to your employment agreement with your employer. The next time you sign a terms of service on your phone, scroll through it, and I can almost guarantee you there's going to be an arbitration agreement in the terms of service. So why do contracts have arbitration agreements? Well, arbitration is a more cost-effective and faster, more efficient way to adjudicate disputes. Say you have a dispute with your cell phone provider or your employer, or really any company from whom you purchase some sort of good or service. Going to court can cost tens of thousands of dollars, hundreds of thousands of dollars, depending on how far along the case is and what's involved. And that can be really onerous for someone who's trying to resolve a dispute around, say, owed wages or a faulty product. Arbitration provides an alternative forum to resolve that dispute. It's not court, it's a private setting. A lot of times these arbitrators are former judges, but there are lawyers too who are neutral arbitrators. When you go into an arbitration, it's sort of like going into court, except it's a less formal of a process, it's a more streamlined process, and it's not as public of a process. Although there are definite benefits when it comes to the efficiency and the cost of arbitration, there are also downsides. By signing an arbitration agreement, you can lose your right to a jury trial. That means you lose your right to go to court and stand in front of a jury and present your case and have a jury of your peers decide the outcome. You are shunted into a system where one person, an arbitrator, is going to decide the final outcome of your case. There are studies that have shown that arbitration can be subject to repeat player bias. If an arbitration provider is the go-to provider for a particular company, say a big company that has a lot of disputes that go into arbitration, that customer is going to be bringing so much business in the form of disputes to this arbitration provider that not necessarily explicitly, but implicitly, the provider becomes biased in favor of that repeat client. And so there are studies that have shown, for example, in employer-employee arbitrations, the employer win rate, the amount of times an employer wins an arbitration, can be significantly higher than the amount of times an employer wins in trial in the same types of cases. And that's an example pointed to by these studies of this repeat player bias in action, that it can be the case that an employee is less likely to win in arbitration than they are in court simply because the employer is a repeat player, a repeat customer of that arbitration provider. Now, it does bear noting that really well-reputed arbitration providers take a lot of care to make sure that their arbitrators are neutral, that the rules that they have in place are there to ensure fairness. So it isn't the case that going to arbitration means you're getting an unfair shake. But it is a possibility, especially when the arbitrator is handpicked by the company with whom the dispute rises. A downside of arbitration is also the lack of transparency. Not to mention the fact that many arbitration agreements can have confidentiality agreements in them, which prevent somebody from talking about that dispute outside of arbitration. But even without that, arbitration is an inherently opaque process. Unlike courts, which have public dockets that anybody can access, arbitration providers are private companies, and they don't have those same requirements. There isn't a right for the public to access arbitration providers' dockets like there is a right for the public to access court dockets. And so it can be very difficult, if not impossible, for somebody to see prior cases in arbitration against a particular respondent, a defendant, a company. This can be really troubling in a case like discrimination, where it's important to see if there have been similar claims against this company in the past, because that actually helps your case by showing a pattern in a practice. You can't show a pattern in a practice if you can't even see prior cases for the same claims against that company. Arbitration also has the downside of procedural constraints. In court, you have a lot of tools at your disposal to get information, called discovery tools, and those are set by state law or federal law, and those can be pretty broad. In arbitration, those tools can be significantly more constrained, and that can really impact your ability to do a thorough investigation in arbitration. There's a law, a federal law called the Federal Arbitration Act, which basically creates this liberal federal policy in favor of arbitration. So if any state creates a law or has a court decision that is hostile to arbitration, that would make it easier for individuals to get out of forced arbitration agreements, then that federal law basically strikes those state laws down. It preempts those laws. The federal law says you can't make laws that are hostile to arbitration. We, the federal government, think everybody should be able to agree by contract to arbitrate disputes and therefore create more efficiencies and unburden the court system. This can be really problematic because it isn't the case that everyone is agreeing to arbitration. It's one thing if sophisticated parties get together and say, we've thought about it and we think if we have any disputes that come up in this commercial transaction, we should go into arbitration because it'll save money and it'll be cheaper and faster and great. That's the situation where agreeing to arbitration seems reasonable and totally in line with the Federal Arbitration Act and why we have arbitration in the first place. But then you have this entire other bucket of arbitration situations, which now comprise the vast majority of arbitration agreements, which is corporations with a lot of bargaining power and individuals with almost no bargaining power. How much bargaining power do you actually have when you go to sign your contract for a new cell phone? You don't negotiate with AT&T about your cell phone terms and conditions. You can't negotiate when you get something on your phone to try an app that requires you to click through the terms of service. There's nobody to negotiate with. It isn't reasonable to expect an individual to read and understand an entire terms of service on a tiny screen, let alone find someone to negotiate with about the specific terms of the arbitration agreement in those terms of service. So it creates a very unfair landscape, and one that, in my opinion, is completely outside the scope of what was originally intended when Congress passed the FAA, the Federal Arbitration Act. Now, I've spent the first half of my career almost exclusively fighting arbitration agreements because the kinds of cases that I do are representing people against corporations for wage and hour violations, consumer rights violations, elder abuse, and invariably there is an arbitration agreement involved that the people we're representing didn't realize they were signing, didn't understand. So the question has often come up, well, how do we get around this arbitration agreement? It becomes a much higher stakes question when you're doing something like a class action, because the arbitration agreements not only force you into arbitration, but they can also force you into binding individual arbitration, which means you lose your right to bring a class action or a collective action. You lose your right to band together with other similarly injured people, and you are forced to go into individual arbitration on your own. So bringing a class action, holding companies accountable on a systemic level, becomes very difficult when you have individual arbitration agreements. So there are a few ways to get around arbitration agreements. Well, first, if you signed a contract in the last 30 days, go back right now and look at it. Does it have an arbitration agreement? And if it does, is there a provision that allows you to opt out? Many arbitration agreements will, in the arbitration agreement, say you can opt out within a certain number of days from signing this agreement by emailing or writing a letter saying, I opt out of the arbitration agreement. If you have a contract that allows you to do that and you want to, do it, because that will opt you out of the arbitration agreement and preserve your right to pursue those claims against that company in court and in front of a jury. If you don't have an opt-out or it's been too long, there may be other ways to get around an arbitration agreement. One way to get around an arbitration agreement can be fraud in the inducement. I had a case where I represented a potential class in a class action of restaurant workers. And these restaurant workers had signed an arbitration agreement as a part of their employee onboarding process. Now, my particular clients were Spanish speakers. When they went to read their employee handbook and their onboarding documents, they were provided with Spanish language versions of all of those documents by the company. And the company represented to them that these are the Spanish translations of these English documents. Read the Spanish versions and then sign the English documents because it was on a computerized system. And they did. What the company omitted from the Spanish language documents was the arbitration agreement. There was an arbitration agreement that was in English as a part of the packet that they signed, but the Spanish documents they were given did not have that arbitration agreement in them. The court found in that case they were induced to sign these English documents under false pretenses. They had been told that the Spanish documents they were provided were an accurate representation when actually they omitted maybe the most important document of them all, the arbitration agreement. Fraud in the inducement. There have been a ton of other cases where I've successfully argued that arbitration agreements are what's called unconscionable, that they are so unfair. They are so unfair that they can't possibly be valid. They are both substantively unconscionable. The actual terms of the arbitration agreement are really one-sided. Maybe they make the employee pay the entire share of the filing obligations in arbitration. Maybe they impose overly burdensome restrictions on discovery in the case, and they only do it to the employee and not the employer. They are substantively one-sided and unfair, and they are procedurally unconscionable. There's something about the way that arbitration agreement was provided to the person that is unfair. Maybe it was a very coercive environment. They were provided the documents and told to sign it and not given any time to read it. Maybe it was in such fine print that they couldn't possibly have read it, or they weren't shown all of the documents and just told they have to sign it. Something about the way that arbitration agreement was given to them was unfair. Substantive unconscionability and procedural unconscionability. Now, Congress also passed a law that ends forced arbitration in certain sexual harassment and sexual assault cases, recognizing perhaps that in these cases, among all cases, sending a survivor of sexual harassment or assault to forced arbitration really does more harm than it does good, both to the individual and society as a whole. Now, the Disney arbitration story is probably one of the craziest arbitration stories you've heard. It's also probably one of the only arbitration stories you've heard, because the ones you haven't heard are the ones that went to arbitration. And that itself is the main issue. How is the public supposed to be aware of the actions of these corporations that have millions and billions of dollars, that have such an unequal amount of bargaining power against consumers and employees and individuals, when any disputes that, if they saw the light of day, might create real change, are shunted into private, confidential arbitration behind closed doors? Arbitration should absolutely be an option. It is cost-effective. It is faster. And you know what? Not everybody wants their name on a public lawsuit just to resolve a dispute. But it should be a choice, and it should be an informed choice. The problem with the current state of the law around arbitration is Too many times people are denied that informed choice and they are forced into a situation that deprives them of fundamental rights. So the next time you sign up for a service, you buy a plane ticket, you enter into an employment agreement, read that contract for an arbitration agreement. Look at it. Decide, do you want to be in arbitration if any disputes arise? And if you do, great. You've made that decision. And if you don't, then see if there's an opt-out clause. And if there isn't, what's stopping you from talking to the person who gave you the contract and saying, hey, I don't want to be in arbitration. I want to opt out. It's worth a shot. If you made it this far, kudos to you. I could spend all day talking about this stuff. I don't know how long people care to listen. But if you enjoyed it, like it, add a comment below. If you hated it, add a comment below, and I will see you next time.